So we had a conference call to prep for this a couple of weeks ago, and somehow I walked away from it with the instruction that I wasn't allowed to have more than 6 slides. So if I misunderstood, I apologize.
That was probably me.
There are about 6 slides. I think what I'll do today is just give a very 30,000-foot overview of the sort of issues that are driving the conversations in the U.S. about the sharing economy, right? And some of them are tax issues, which is where I come from. My wheelhouse is tax, that is. But a lot of them are not tax issues, and a lot of the drivers, I think, are actually labor law issues. So I'll touch on those as well. I'll talk about our 2 categories. We don't have a third one. Give you a sense of the applicable tests, which is probably less interesting than one might think, because I suppose common law is common law. And then give to you some updates on the status of the main litigations, the Uber litigations and Lyft litigations happening in the U.S., and then talk a bit about tax and Social Security. And if there are follow-up questions, feel free to send email. So I made a colorful thing, which if you can't see, I'm sure will be online later. And those are basically just the sort of drivers of why the distinction between employee and independent contractor status matter. We do have the 2 categories. There is not, I think, uniformity in how we test for those categories across a variety of areas of law. But what is not in question is that they are significant in a number of legal areas, right? They are more significant, I think, in some areas than others. I would say that probably the biggest driver right now on why people worry about the employee-independent contractor distinction is the labor protections, right? It's the collective bargaining under the 1935 National Labor Relations Act. It's all the overtime, minimum wage, labor law, health and safety regulations. Those are our Fair Labor Standards Act, Family Medical Leave Act, OSHA, the Occupational Safety and Health, and also various state law protections. It turns out that if you're an employee, I think you get more of those protections than if you're an independent contractor, otherwise known as basically kind of running your own small business, right? For federal tax laws, there's a number of tax administration and compliance issues that stem from one classification versus another, and also the way we collect the Social Security taxes differs a little bit depending on whether you're an employee or independent contractor, although I think that the Social Security has not been the primary driver of why we worry about independent contractor versus employee, right? Anti-discrimination statutes, that's another big one. A lot of the protections of our Civil Rights Act hinge on employee status. And then there's a couple of fun things that we don't normally think of. Of course, tort and agency is where it all came from way back when dinosaurs roamed the earth, but also things like copyright ownership. There was a big Supreme Court case from many years ago about how if you're an artist, right, working for a company or something, and you create the art, well, who owns the copyright? Arguably stronger copyright protections if you're operating as an independent business person. Antitrust laws, I'll talk a bit more about that in due course. That has really sort of emerged as a wild card in stymieing sort of more piecemeal attempts at getting piecemeal labor protections for workers that might otherwise be classified as independent contractors. Anyway, a little bit of history, right? That's sort of the overview of why we care about it. The debate is not new, right? Independent contractor versus employee has been around for a very long time. Became a thing with the National Labor Relations Act, again, 1935, which gave you sort of workers' right protections, collective bargaining rights. What happened was that the 80th Congress sort of followed up with the Taft-Hartley Act, which sort of revised the definition of employees and independent contractors to carve out supervisors and also independent contractors from the protections of the National Labor Relations Act. At the time, apparently, the supervisor clause was seen as more material than the independent contractor clause, but of course the history showed otherwise, which is now if you're an independent contractor, you don't get the NLRA protections, and so a huge incentive, I think, for businesses to find ways to classify workers so that they don't have to satisfy the requirements of the labor law protection. So that's really where it all comes from, right? The debate, I think, has happened on the federal, state, and the local level, right? It's an ongoing fight. I would say that the sort of new gig economy has really put a lot of pressure on the debate, but the debate is not. It's just not that new, I don't think. Okay. So we have a number of legal tests, right? So last slide showed important for a bunch of different areas where we care about independent contractor versus employee. It turns out that there's not one unified test that applies to making that determination. Probably the oldest big test out there was the sort of control test or the common law of agency test. A restatement third of agency law specifies that an employee is an agent whose principal controls or has the right to control the manner and means of the agent's performance or work. Right, so the emphasis there is on control, and they sort of apply a factors analysis to making that determination. And so the attendant result is all the usual weaknesses we find when we have a factors analysis, right? There's also the economic realities test, and this one tends to be applied by the Department of Labor in doing FLSA, Fair Labor Standards Act analysis, right? And that test looks at control, but also more, I think, at the sort of what they call economic realities of the employment relationship, things like whether the work done is an integral part of the employer's business, whether the worker's managerial skill affects the opportunity for profit, so ability for the worker to take the upside is, of course, predictably one of the factors, right? And also sort of relative investment of the worker compared to the employer, whether the worker has special skills, that sort of thing. The states tend to apply something that, for unknown reasons, is called the ABC test. Again, a sort of a factors test that looks at freedom from control, whether the work done is outside the ordinary course of the company's business, and also whether the worker is customarily engaged in independent trade, occupation, profession, or business. And finally, we have the IRS 20-factor test, which is a little bit specific to the IRS. Not surprisingly, it has 20 factors, which can be grouped into behavioral factors, financial factors, and sort of like other sort of nature of the relationship factors. Right? So I think in some sense, for sort of common law jurisdictions, probably not a whole ton of difference. And the tests do differ at the margins, but I don't think there's a huge, giant difference between them. But I think the important takeaway is that the different agencies and courts in different states, and also agency, IRS, I guess is an agency, really sort of do their own analysis. So then the question is, well, now we are confronting this new sort of way of doing things to be maximally neutral. Which thing is driving what, right? And that really is, I think, sort of the question. So. I guess let's turn now to talking about the developments that have been happening with respect to our new ways of doing things, our gig economy developments. And so here I have just a few major points, right? I think probably the big thing that probably ought to be emphasized, because there's been a lot of noise, right? But actually there've been no major sort of substantive changes so far in our classification, right? There's been a bunch of lawsuits. Nothing really substantive has been decided. Some labor tribunals have held that Uber drivers are employees, not independent contractors. But to my knowledge, I don't think there's been a big court decision come down yet. And even if there had, right, it wouldn't bind across the entire country, right? It would bind a class, right, or not, right? So speaking of the TNC litigations, there's actually been, and I know I'm not really a litigator or a labor law person, but I think there's been a bunch of quite fascinating developments in the TNC litigations as a matter of strategy, and also as a matter of the things that are blocking that strategy and the things that are successful, right? So not surprisingly, some of the big litigations are driven out of California, because that's where Uber started, so they've been there the longest, most opportunity for lawsuits. Also, I think a vaguely friendly worker jurisdiction, right? So a lot from California, Massachusetts, New York, I think that's the case in Florida, right? And again, those litigations tend to be driven by the state labor law concerns, things like minimum wage, payment for overtime, the employer obligations to reimburse the expenses of drivers if they are employees, right? So those are the causes of actions when you look at the complaints that are stated in those complaints. Tax has not been a driver so much. much. It's really been sort of the labor law stuff. And then as a matter of the litigation strategies, they've really been brought as class actions, right? So consolidating a number of drivers into a class, right? Obvious reasons there. If you can get the decision to bind the class, right? Much more impact, although again, still sort of limited because one court and will not necessarily bind the circuit in the other state, right? So still limited, but there's a clear advantage to bringing these things as class actions. So that had been the strategy. And so what happened in the Uber litigation was the district court, which is the lower court judge, certified the class, right? And then there was a Ninth Circuit, well, it was certified the class, there was a settlement agreement. A judge said, no, I think this is too low. This is in the Uber case, right? But it turned out the reason it was too low was because the plaintiff's attorneys perceived significant risks because of these arbitration clauses that a lot of the drivers had signed when they signed up to drive for Uber, right? And the arbitration clauses said, thou shalt not bring a class action. Well, it said something more detailed than that, but really it said, we agree that if we have disagreements, these shall be resolved through arbitration. And so the Ninth Circuit came down a while later and basically I guess in layperson's term, you would say gutted the class. What they really did was they stayed the class action pending a resolution of this thing, the question of whether these arbitration clauses were binding. Stay applied to 5 litigations. So the commentators say, great, now they've really gutted the class. The Ninth Circuit decision, that's the appeals court, goes down to the district court, and the district judge says, well, I'm going to stay this entire thing until we decide the question of the arbitration provisions. So that has sort of stymied the class action approach to litigation, at least for now, right? Although we'll see how the merits end up turning out, right? So that's happening. On the one hand, we have these arbitration provisions that are sort of stymieing the class action approach, right? I think at the other end of things, we have the development of these like piecemeal approaches to worker protection, right? And I think that is really a question of strategy. If we are not being successful in classifying our drivers or our other workers as employees, and we're not getting them the labor protections this way, well, how else could we do it? We could have local ordinances. For example, there's an ordinance in Seattle that basically gives independent contractors the right to collectively bargain, right? And so, of course, that's a two-edged sword, right? On the one hand, you say, well, we're not getting it through the litigation, so maybe we go piecemeal. Well, once you go piecemeal, it puts less pressure on a worker-favorable outcome on the litigations, so there's that set of tensions going on there. What happened was, in the face of the Seattle ordinance, the U.S. Chamber of Commerce, of which Uber and Lyft and other platforms are members, launched a lawsuit, and the lawsuit was on a bunch of things, but the ground that turned out to be compelling to the Washington District Court was the antitrust ground. And the argument was a rather circular thing of like, well, if these people are independent contractors, then they are small businesses. If they are small businesses, they cannot collude and be anti-competitive, and therefore the Seattle ordinance, which basically lets them collude and be anti-competitive, is barred on antitrust grounds. Okay? So on the one hand, the class action strategy has been stymied by the arbitration provisions. Here, I have a funny slide of that, and we don't want that. Right? On the one hand, the class actions have been stymied by the arbitration provisions. On the other hand, the sort of incremental approach is being stymied by the antitrust allegations. So long story short, that Seattle ordinance has also been, stayed the right word, maybe enjoined, stopped for now, pending the outcome of the antitrust litigation, which is going to take a while. Okay, so that's the sort of thing that's been happening in the sort of fights over worker classification. Again, very much driven by the transportation network companies, which I think makes sense because Uber is not only big, but also I think there's a better case for employee classification in the ride-sharing sector than, say, in the Airbnb home-sharing sector, right? So the TNC litigations have really sort of driven things. There have been some academic proposals to have a third category, but that really has kind of remained theoretical for now, right? I think for those of us who are interested in the sort of law and economics, right, you can wonder how much drawing, and the sort of a material question for the audience here, drawing a third category category is going to be a good, efficient thing, or whether just having more lines is just going to add more confusion on an efficiency ground, and whether as a matter of pragmatism, whether having a third category with some protections will just end up gutting actual worker protections on the employee side more than we already have. Okay, so that's my tax lawyer a description of not tax things. So talking about tax now for just a couple of minutes. Tax really has been, I guess, a wild card in all of this, and from my point of view, a sort of underappreciated wild card. My co-author Diane Ring and I have written a couple of papers which are sitting on SSRN, you're welcome to take a look at, talking about what the sort of tax compliance issues and other sort of behavioral issues affecting Uber drivers, but also other workers in the sharing economy are, right? And so a couple of points. Number one, sad to say, my sense is that the labor law people in the US are not really talking about tax. In fact, someone told me that point blank at a conference a few weeks ago, so that went well. So tax is not really driving things on the worker classification side, but I think it might have behavioral impacts that are sort of unnoticed that might either encourage or discourage the sector. The main thing for tax compliance is that we don't really have the system set up to deal with these people in these micro business transactions. So these people are really filing just like other small business owners, right? But of course, you know, as one Uber driver on an internet forum that we were studying said, well, you know, the problem is this tax compliance structure does not scale well for a one-car fleet, right? So if I'm a one-car driver and I'm filing a Schedule C and having to do all my administrative paperwork and figure out which miles count, right? So the big question for the Uber driver, we have this standard mileage approach that if you're using personal use property to drive around, right, you have to really sort of allocate your miles between when I went to visit mom versus when I was driving a passenger around. And well, what if I dropped off a passenger, went off to visit mom with my app still on, and then came back and picked up another passenger? How do I allocate those miles? So the compliance effects, I think, are pretty significant, right? And what we see is also a delayed significance, which is that you start driving for Uber, and then April 15th comes around next year, and you're like, oh crap, like I didn't realize I was going to have to do all that. What we don't know, so Diane and I spent a while surfing the internet and finding out all kinds of things that people were saying, Uber drivers were saying about tax compliance, but what we don't know is the long-term effects of those compliance costs, right? We don't know whether that's going to, in the long run, discourage people from driving or not. Another thing, and I'm running out of time. I have a couple minutes. Yeah, I guess the other thing on the Social Security side is that there's sort of two, do I have a slide on this? I think I have a slide on this. Yeah. This is my most annoying slide by far, which is that the Social Security system has a 12.4% Social Security tax and a 2.9% Medicare tax, and this is all to fund health care and Social Security in your retirement. For employees, the worker pays half, and then the employer pays half. But for independent contractors, you pay the entire thing, right? And then you have a deduction for what would have been the employer half on your income tax return, right? So either way, right, it is not like Helen had mentioned here, which is that there's no top up, right? Whether you're working as an independent contractor or as an employee, right? Someone's going to pay the whole tax. The only question is who, and of course I don't know the incidence, right? The big question is, you know, yes, as a matter of legality, I can say as an independent contractor I pay my whole thing, but I don't know the incidence and how it's going to impact wages, right? In a rational world, you might think that the independent contractor should be able to bargain for a higher wage to cover the fact that they have to pay the whole self-employment tax, and of course the world is not rational, so that's probably a pipe dream, I think, although I haven't run the numbers, obviously, not an economist. And then the income tax deduction that the independent contractors get should put them on exactly the same footing as the employees. So, but in the real world, I think what we find is independent contractors may not be able to bargain for higher wages. They might be limited, employees tend to be more limited in tax expense recovery, but of course the employees get better non-tax protections. So at the end of the day, I don't know how the incentive works as a matter of sort of dynamic analysis. I think it's plausible that lower wages in the independent contractor sector end up affecting the payouts on Social Security on the back end, but it's not as sort of like saliently stark as saying, gosh, the one set of people are not putting in enough contributions. That's certainly not the issue there. So there's a whole bunch of more tax issues. I think I'm probably out of time. So, but I'm happy to talk later and fill in the blanks.
We'll do questions. Thanks.